And hello, welcome to the Employment Law Show. I'm John Scholes, your host, and the brains of the operation sitting right there, Lior Samfiru. We talk about employment rights and severance and just going through that tangled web of employment, and something we all do for many years, decades as a matter of fact. It's a very important part of your life. If not the most time you spend, 8 hours a day plus, is that your job when you think about it? That is thousands of hours, literally thousands of hours. So there's all kinds of things you need to know. Coming up in this show, we'll get to everything you need to know about performance improvement plans. What are they? How do they work? We'll fill you in on that. We'll get to some phone calls from our radio show anytime you want to check out where that is, EMPLOYMENT LAWYER.ca. And always the number to reach out, 1-855-821-5900. First, though, week that was, what's going on?
It's always going on. What's always going on is that I talk to a lot of people, which is great. I don't even know when I have time to practice law because I'm on the phone all the time, on email all the time, answering questions.
Delegate.
That's a good idea. I should try that. And I speak with people all the time about workplace rights. You know, what I do here on the show, I do this in my office all the time. People call me with questions, people email me with questions, people text me with questions, you name it, and I answer them all. That's wonderful. That's what I want to do because there's always solutions to workplace problems. They're not always perfect, but they're usually pretty good. There's solutions. So if you have a workplace problem, your boss did something or said something, or maybe you found out that the company is making some changes or restructuring, what does it mean to your job? Maybe the business is being sold or bought. What does that all mean? You can always reach out to me. You can always call me. I can tell you what you need to know so you don't stress out, you don't lose sleep over it. No need for that. And of course, on this show, just by watching this show, we'll be able to educate you every week about so many things to do with your job and workplace. But week there was specifically a situation that came across my desk over the past few days or so. I spoke with a gentleman who had actually been accused by a coworker of bullying and harassment. He had been accused. And he met with the company. He gave his side of the story. He didn't feel that he did anything wrong. And the company said, fine, we're going to investigate this. But in the meantime, we're going to suspend you without pay. And we're going to let you know when we're ready to have you come back to work, to let you know what we've found. So he'd waited a few days. He'd waited a week. He hadn't heard back from them. Contacted the company. We're still working on it. 10 days, still working on it. 2 weeks, still working on it. Finally called me. He said, Lior, what gives here? I'm suspended without pay. I'm not earning any income. I don't think I did anything wrong. What gives? Well, let's start with the proposition, John, that a suspension without pay is actually illegal for most people. The company does not have a right to suspend without pay. They do have a right to suspend with pay as a disciplinary measure, as long as it's justified. They can't just do that willy-nilly. But they don't have a right to suspend without pay. If a company suspends you without pay, that is actually a constructive dismissal. You do not have to accept that. Now, in this case, it's even more absurd. They're suspending him without pay, which is a disciplinary matter, while they're determining whether he should be disciplined.
Already been punished.
I mean, isn't that putting the cart before the horse? I think it's the definition of it. Yeah. So, no, they can't do that. And even if discipline was justified, they cannot suspend them without pay. We're talking about non-union environments, of course. So if your employer ever suspends you without pay, you have a choice. You can choose to accept that suspension and come back to work, or you can choose to treat that as a termination, as a constructive dismissal. The problem, John, with treating that or allowing that to happen and going back to work is you've given the company the right to do it again. And the next time they suspend you without pay, you may not be able to do anything about it. You may be better off to treat that as a constructive dismissal and leave with severance. So many people, employers and employees, I'm going to be surprised to know that a termination or a suspension without pay is illegal, is actually a termination. If that happens to you, I want you to reach out to me.
1-855-821-5900 is a number. EMPLOYMENTLAWYER.ca online. That is where you go as well, the resource to find our radio show. How you can catch that and tune in, and maybe you'll call into the show, and your call might make it on here on the Employment Law Show. We'll get to our first call of the day right now.
I actually is currently on maternity parental leave, and I'm due to come back into resume my full-time job, which I've been there for 16 years now. However, I was just called in from my employer about a week ago saying that they want to have a meeting with me to discuss the expansion of the department. However, when I got there for the meeting, I was presented with a termination letter without cause. So as far as I understand, the person who had hired on before I left the leave, which I've trained also, was hired on as a 6-month contract, but now she is still there and doing my role.
Someone didn't get the memo. Don't mess with mama.
John, we talk about maternity leaves, parental leaves on our show often, and you always ask me, do we really need to talk about it this day and age? Do people not know? Well, right there, that message or that call that we got on our radio show tells you that still a lot of employers don't know that that is so illegal. No, they cannot do that. An employer cannot decide that they want to keep the replacement if you're on a parental leave. Their obligation is very simple. They have to let you take the leave, and then they have to take you back to the same job, the same duties, the same pay that you had before you took the leave. They cannot do anything else. There's no wiggle room. There's no exceptions. There's no, well, but, none of that. So in this situation, as I understand it, not only is she being let go, the company can't even say that, oh, it was just a big restructuring. They simply want to keep her replacement, which she trained.
Right.
That's ridiculous. That's illegal. That is a human rights violation. That's a violation of the Employment Standards Act. And after 16 years, not only is she going to probably be looking at 17, 18 months of severance, she could be looking at significantly more than that also by way of human rights damages. It's illegal, so please, if you're taking a parental leave, whether you're a mother or a father, you have a right to take that leave. You have a right to be gone for the period of time, but you also have a right to your job. Your replacement cannot be kept over you. If it's a restructuring and that the whole department shut down.
Right, that's what I was going to ask.
That's different.
Okay. Yeah.
But that is rare, John. In my experience, even now, these days and age, when we're supposed to be more enlightened and knowledgeable, I still see situations like that all the time where employers don't bring back a person from maternity leave or parental leave. That is illegal. One of the most basic violations of human rights that we have in this country.
Wonderful new tool out there. It's recent and it's gaining some momentum for sure. EMPLOYMENT We love this. Tell me about it, pal.
I can't talk about it without having a smile on my face because it was so long in the works, so long it took us to put it together. I'm very proud of it. Something that idea that I came up with a while ago. It took us a while to actually bring it to life. EMPLOYMENTLAWYER.ca to find out your legal rights. Easy to do, free, anonymous. It takes seconds to do. So when you go to EMPLOYMENTLAWYER.ca, you can choose a number of tools. You can find out how much severance you're owed. You can find out if you're an independent contractor or an employee, if the company has cause to let you go, if the company improperly harassed you, if you have a disability issue, all that and more you can do on EMPLOYMENTLAWYER.ca. It's like having myself or one of my lawyers on my team with you at all time, in your pocket, on your phone, on your laptop, whatever it is. Nothing like that exists out there. This is not some general information where we tell you, here's what a constructive dismissal is. No, you'll answer questions and it will tell you right there, have you been constructively dismissed? Have you been a victim of harassment? Yes, no, and why? Check it out. EMPLOYMENTLAWYER.ca.
Want to take it out for a spin? We're going to run this scenario through it, and I'll get you to comment on it. Lior says, I'm being bullied relentlessly by a new coworker who joined us a month ago. When I approached my manager, I was told that there were personality quirks that I should ignore. I've enjoyed my job for the last 4 years, but I feel like my only option now is to quit.
So workplace harassment obviously is a very serious issue. You should never have to suffer from workplace harassment. You have a right to a healthy, a supportive, a positive work environment. And if your company violates that right, that is illegal. That potentially could be a human rights violation. It can definitely be a constructive dismissal. And this person did the right thing. They talked to their boss, they talked to their manager, and nothing was done about it. Well, now it's time to treat that as a constructive dismissal. If you're in that situation, let me know. Call me, email me. I'll help you deal with it. You can also, though, as we've been saying, go to EMPLOYMENTLAWYER.ca to determine whether what's happening to you is, in fact, illegal. So in the EMPLOYMENTLAWYER.ca website, you'll see a tool dealing with workplace harassment. You choose that and you answer some questions.
That's great.
So let's plug that information. This person's been there for 4 years. He was harassed by a colleague. Unprofessional treatment is the type of harassment. She asked for help. Well, the result that we get there is, yes, this is inappropriate workplace harassment. It assessed that information and determined, yes, this is inappropriate. Now that you know that it's inappropriate, you know what to do. You can contact me. You can do that, by the way, directly from EMPLOYMENTLAWYER.ca. That's how easy it is to use. If you've been wondering, was this considered harassment? Is this something that I can do something about? EMPLOYMENTLAWYER.ca.
All right, coming up here, everything you need to know about the Performance Improvement Plan. How does it work? We'll dig down, get into that after a short break. 1-855-821-5900 to reach out by phone and online, EMPLOYMENTLAWYER.ca. Employment Law Show continues. Hang on. You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to EMPLOYMENT LAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENT LAWYER.ca. And welcome back, Employment Law Show, 1-855-821-5900 and EMPLOYMENTLAWYER.ca is where you want to go. This is interesting. Everything you need to know about performance improvement plans. This time, I'm not on the hot seat. You are. So I'm going to ask you the questions and you'll answer them correctly. How does that sound?
I think we could do that, yes.
Okay. What is it? What's a performance improvement plan, first of all?
As the name suggests, it's a plan usually put in by an employer for those employees that they consider to be underperforming to allow the employee to get better. Usually a performance improvement plan is going to outline the reasons for the plan. It's going to outline what the goals are. So in other words, you have to sell this many items or you have to meet these criteria. And it's also going to say, it should say, what the company is going to do to help you get there. And it's going to give you a timeline. So you have to do this by March the 1st or August the 2nd, whatever it is. So a performance improvement plan is a tool used by employers to bring along those employees that they feel are lacking or falling behind. The thing is about it, it's not always legitimate. It's not always put in for good reason. And I get a lot of questions often from individuals that have been put on a performance improvement plan wanting to know what to do. It's never a pleasant thing. No one's ever said, yeah, I'm so happy, gosh darn it, I've been put on a performance improvement plan. That's amazing. No, it's a stressful thing. Oh, yeah. No one likes to have that happen. So we're going to talk a bit about what to do if you're ever in that situation.
Well, you mentioned it's stressful. So me as an employee, what do I do if I disagree with the plan?
Well, and that's the thing. Oftentimes people may tell me that, well, you know, it's not accurate. It says that I've been doing things that I'm not, or that I'm not doing things that I am. Well, my answer is very simple. Well, you have to say so. You can't just be taking it and accepting it and being silent. Being silent is the same as saying, I accept, I agree. If you don't agree with the performance improvement plan, you have to say so, and you have to say so in writing. You don't agree, send an email. Always in writing. If it's not in writing, it doesn't exist.
Yeah.
And tell your employer, you said that I haven't been doing these 3 things. Well, here's what I've been doing, and here's the documents that prove that. Or you're saying that I haven't been working on the Smith project. Well, here's the work that I've been doing on the Smith project. Now, it's okay to acknowledge the things that you may have done wrong and things you can improve on. But if there's something in the performance improvement plan that's not complete, that's not accurate, that's not fair, you have to say so. By saying so, you're going to make it that much harder on the company to rely on the performance improvement plan if down the road they want to let you go.
Everything you need to know about performance improvement plans, that's what we're talking about. You want to reach out, 1-855-821-5900. What if the employee still disagrees with the improvement plan, decides not to protest it? They just quietly go by.
Bad call. That is a very bad thing to do. As I said, if you are silent, if you don't do anything, maybe you don't want to make your employer upset, so you're not going to say anything. It's exactly the same as if you've said, yes, I agree, I accept it. The problem with that is down the road, if the company wants to let you go and they say, well, we put you on a performance improvement plan and you didn't meet those targets, it's going to be very difficult to say, well, wait a second, that performance improvement plan was not correct, was not accurate. It said that I was doing things that I wasn't. Well, why didn't you tell us back then? So if you want to make your company's job more difficult in terminating you, if you want to make your job security to be stronger, you have to respond. You have to put that in writing. You have to tell the company why you disagree with it. If you're not sure how to do that, if you're not sure the right tone to take in doing that, let me know. As long as it's in writing, as long as it's professional, you can't go wrong.
You know, you said a couple minutes ago that it can be very stressful if you're singled out and put on a performance improvement plan. So what if the stress gets to an extreme level? Can an employee, say, go on a medical leave?
Absolutely. So in some situations, maybe it's triggered by the performance improvement plan, or it could be other reasons. Workplace stress, it's a real thing, especially these days when everything moves so fast. If you feel you can't work, if your doctor agrees with you that you cannot work, you can go off on a medical leave. And you don't have to tell the company why. You don't have to tell what the condition is. They don't have to know that it's workplace stress. As long as the doctor says you can't work, you can go off work. And the company can't use that against you. They can't say, well, we put you on a performance improvement plan and you didn't meet the target because you weren't here. No, that would be illegal. That's a human rights violation. So whether you are on a performance improvement plan or not, if you can't work, if there's something medical that's preventing you from working, whether it's depression, anxiety, bad back, bad hip, whatever it is, as long as a doctor backs you up, you can be off work as long as you need to, and the company can't do anything about it, and they can't point to the performance improvement plan to try to let you go while you're off work.
The key to that is the doctor, right? You need
Always.
professional medical notation, right?
It's not enough for you to say, I can't work. It's not enough for you to say, I want time off. Your doctor has to agree with you. You need to provide something from your doctor. But the key to remember is there's no time limit. You could be off for a day. You could be off for a year. Anything in between. As long as the doctor supports you, you could be off.
Everything you need to know about performance improvement plans, reaching out 1-855-821-5900 and EMPLOYMENT LAWYER.ca. Employee is on the performance improvement plan, fails the plan, doesn't reach the targets. Can they be let go without severance for cause?
And that's often what an employer is going to try to do.
Yeah.
So they're going to put you on a performance improvement plan, and if you don't meet all those targets, they'll say, well, we gave you an opportunity. We told you what you needed to do. You didn't. So we're going to let you go. And by the way, that's for cause termination. They'll say no severance for you. Not so fast, not even close. The fact that you may not have had great performance, the fact that you were put on a performance improvement plan does not mean you can be let go for cause. I said that on an earlier show that we did. It's very difficult to terminate for cause. And you being on a performance improvement plan does not mean you can be let go for cause. The company would have to show that you've done something so bad, so awful, that essentially you were deliberately doing a bad job in order to get terminated. Maybe then it's cause. Short of that, bad performance, inadequate performance, not meeting the targets is not cause. You're still going to be owed your full severance. That said, you never want to even engage in that battle, which is why I say if you can, always respond to the performance improvement plan. That way the company doesn't think even of trying to let you go for cause.
At what point during this whole process is it a smart idea for someone to reach out and contact you?
Honestly, as soon as you're put on a performance improvement plan that you disagree with. If it's something that you agree, if it's legitimate, probably not much that I can do. But if it's a performance improvement plan that you don't think it's accurate, you don't think it's fair, or maybe you think it's being done in bad faith. Maybe you got a new boss that's trying to push you out, so it's putting you on a performance improvement plan. Seen that before. You want to reach out to me. We need to strategize how to respond. We need to strategize as to maybe there's someone else we can talk to over and above the manager's responsibility, maybe an HR person or someone more senior, that we can let them know, hey, here's what's going on. This person is picking on me. So if you've been put on a performance improvement plan that you don't agree with, that you don't think is legitimate, you want to reach out to me as soon as possible.
1-855-821-5900 and EMPLOYMENTLAWYER.ca to reach online. That is also where you'll find our radio show, as I mentioned earlier. Second call from the show on this show right now.
I have a girlfriend of mine that works as a sales supervisor. A new district manager was appointed to their area. Now, after this manager came on board, they gave my girlfriend a notice of termination effective immediately. The reason they gave, believe it or not, she was sitting on a counter swinging her feet. And that's not grounds for dismissal. They only gave her 1 week's pay after she had been there for almost a year.
She was doing this?
Yeah, she's doing, well, John, I guess I can let you go. Yeah.
Come on.
Seriously.
Seriously?
Well, so we're making fun of that, but here's the interesting thing is, interesting about this is, as silly as that is, and that's objectively silly, there's nothing illegal about it.
Yep.
She can be let go for swinging her feet or not swinging her feet enough.
As long as she gets paid her severance, okay? So the question is not so much, is it a legitimate reason for swinging her feet? That's silly. I can't believe I'm actually saying that. Silly as it may be, they can let her go. They can, what's my example I love to use? You drive a blue car. Sorry, we like people that drive red cars. Out you go.
Out you go. No one's going to do that, I hope, but an employer can do that as long as they pay severance. So the question here is how much severance? They give her a week's pay after a year of service. Spoiler alert, not even close to being enough. So rather than me tell you exactly how much she's owed, let's take that information and plug that into pocketemploymentlawyer.ca so you can see how easy it is. So we're going to go to pocketemploymentlawyer.ca, choose our severance calculator function, plug that information. She's a supervisor, 1 year of service. I picked an age. Let's say she's 43. She was given 1 week's pay. Severance calculator and pocketemploymentlawyer.ca correctly assesses her as being owed 4 to 6 months' pay. Depending on her compensation, that could easily be $20,000, $30,000 more. 4 to 6 months' pay, John, even after only working there for a year. That is correct. So it's not a week's pay. She's been wrongfully dismissed, but not because of swinging her legs, because of the fact that she's owed a lot more severance than 1 week's pay.
Coming up here, downsizing an independent contractor. We'll tackle that after the break. 1-855-821-5900 and employmentlawyer.ca. The Employment Law Show continues. Hang around. Don't go anywhere. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Law Show. It's John Scholes, Lior Samfiru. This is the part of the show where we bounce over the radio show and give you a taste of what happens there every week. Phone calls, lots of them come through. We like to talk about on this show. The next phone call that we're going to play is coming up, well, right now.
Okay, I'm actually calling for a friend. She worked for this company for a little over a year. They're downsizing. They no longer need her services. And because she was an independent contractor, she's not entitled to any severance. What's your take on that?
The old independent contractor excuse.
John, probably one of the things that I have to deal with most often is, in being an employment lawyer, is determining whether someone is an employee or an independent contractor. Because as our regular viewers know, people get misclassified all the time, and I do mean all the time. It's so often that someone is treated on paper or called on paper an independent contractor, but they are an employee. So if you have a regular job, if you go to work, come home, come back the next day, do the same thing, you are an employee. I don't care how you pay your taxes. I don't care if you have your own company. I don't care if you signed a piece of paper that says you're an independent contractor. I don't even care if you charged tax, HST. Don't care. The law determines that if you look like an employee and act like an employee, you are an employee. And why is that important? Well, if you are an employee in the eyes of the law, you have the rights of every other employee: vacation pay, overtime pay, holiday pay, minimum wage, and of course, severance if you lose your job. The big issue that I see often is independent contractors, quote unquote, losing their job, companies saying, oh, well, you're an independent contractor, we don't have to pay you anything. But really, they're employees, their owed severance could be as much as 2 years' pay. So one of the nice, neat tools in pocketemploymentlawyer.ca is the tool that allows you to determine whether you're an independent contractor or an employee. Again, you can find right on pocketemploymentlawyer.ca, find out yourself. If you've always wondered, hey, am I really an independent contractor or an employee? Find that out right now. So let's go to pocketemploymentlawyer.ca. Let's plug this information based on this call. So this person didn't work exclusively for the company. The company determined their hours. They didn't have to pay for their own expenses. The pocketemploymentlawyer.ca, the result we see on the screen right now, yes, it's very likely that you're actually an employee and not an independent contractor. It's as simple as that. Works just the same for you. If you're not sure, you can always call me, but always absolutely just as easy on the weekend, at night, anytime. pocketemploymentlawyer.ca.
Well, we always say if it was that simple, nobody on the planet would ever hire anybody.
Why would they?
Have to pay severance.
Absolutely.
Everyone's an independent contractor.
And vacation pay and overtime and all those pesky entitlements that employers and employees have here, no, they wouldn't pay that. So it's not that simple. If he looks like an employee and behaves like an employee, it's an employee.
1-855-821-5900. Again, the number to reach out, employmentlawyer.ca. There's also terminationquestions.ca. That is where you input your question, and it gets answered rather quickly by Lior, a member of his team. First one for today, as follows, my friend. Says, after being off work for more than a month due to stress, I had no choice but to return after my LTD claim was denied, despite support from my doctor. Another employee just told me they overheard a meeting where my termination was discussed. Uh-oh, what do I do?
Well, there's a number of things we need to break down here and kind of assess. So first of all, if you've been cut off from your disability, but you can't work, or you feel you can't work, and your doctor supports you, then you shouldn't have been cut off your disability to begin with. That's illegal, and you know this. We do another show, the disability law show, that discusses these issues. It happens all the time. So the first thing we need to do is deal with your insurance company. They should not have cut you off. So we could do one of two things: either get them to reinstate you once they realize, holy cow, that they've been called on it, or get you compensation. So right off the bat, that's the first issue. And you should not have to make your situation worse, your medical condition worse, by going back to work when you're not ready, when you're not physically able. Now, beyond that, if you are back to work and you're still unable to work, you maybe need some accommodation, you're still dealing with your medical condition, you cannot be let go because of that reason. That is illegal. Your company cannot do that under any circumstances. So in this situation, it does seem, based on this question that you read, that this person, their termination may be contemplated because they're on a medical leave, or they took a medical leave and they're still struggling. That's illegal. So severance would have to be paid. Yep. But there could be human rights damages. Bottom line is this: if you've been cut off disability before you're ready to come back to work, that is illegal. We need to deal with your insurance company. And your employer can't take advantage of that situation. They also can't say, you've been cut off disability, that must mean you can come back to work or else. No, if a doctor says you cannot work, that it begins and ends there with your employer as well as your insurance company.
We'll get another one here quickly, terminationquestions.com. Second one is this: I just found out that our office is closing in 1 month. I won't receive any severance even though I've been working at the location for the past 8 years. The company still operates 2 other offices in the province. Shouldn't I receive something?
Yeah, absolutely. So let's be very clear. If you've been let go with 1 month's notice, that month's notice does count towards your entitlement. But if this person has been there for 8 years, they could be owed 10 months of notice or severance. If they received 1 month's notice that the company or their location doesn't exist anymore, then they're owed the difference. Yeah. Okay, so that's not even an issue. They'll have to get that paid. The company will have to compensate them for that. Now, if the company is legitimately out of business, it's bankrupt, it's out of money, well, you can't get blood from a stone. But this is a situation where the company is still operating. So the fact that the company may have shut down the location where you're working does not mean you're not going to get paid. You will get paid. And that notice counts towards your entitlements, but it's not your full entitlements. Go to pocketemploymentlawyer.ca, and before you walk off into the sunset, before you assume that you're not owed something, you may have significant entitlements. You want to reach out to me as soon as possible. Talk to me, talk to a member of my team. Don't find out when it's too late that back 2.5 years ago, you would have been owed months and months of pay. We've had that happen on our radio show often. I speak with people all the time that watch this show. They realize they have entitlements, but by then it's too late. I hate those situations. There's a 2-year limitation period. Don't ever walk away from your rights, because if you do, by the time you realize you've done so, it's too late. So if you know somebody, they lost their job, their company's closing, you have to tell them to do the same thing. Reach out to me. Go to pocketemploymentlawyer.ca. Reach out to another lawyer if you don't like me, but you have to do something.
Employmentlawyer.ca. And finally, the number again, 1-855-821-5900. Do not hesitate to reach out to Lior. And as he mentioned several times, we ran through examples. It's new and it's awesome. Pocketemploymentlawyer.ca. Until next time, we'll catch you right here on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.